Hello everyone, welcome to this webinar. I am Shalini and I work with CREA as a Director Programs and Innovation. As a feminist organization that works for gender diversity and empowerment, CREA's objective is always to facilitate conversation that give a space to diverse voices, opinions and stories. The new partnership between CREA and Radio Jamia aims to do this just by launching a radio show especially for women in the campus and in the community. Today's special event on the occasion of International Women's Day is a conversation with senior advocate Rebecca John, who fought and won the criminal defamation case instituted against Priya Ramani, who had spoken out against sexual harassment in the workplace. This is our first collaborative special event with Jamia Millia Islamia, and we are very excited to be starting this journey with all of you. Let me welcome Shohini Ghosh, professor at the AJK Mass Communication Research Center, Jamia, who will be in conversation with Ms. John. The conversation will be followed by a question and answer session in which we invite you to participate. Please feel free to add your questions in the chat box and also write your name and organization. In order to make this conversation more accessible, we are taking help from Manisha and Preeti for sign language interpretation. Thank you, Manisha, and thank you, Preeti. Over to you, Shohini.
Hi, Rebecca.
Hi, Shohini.
Rebecca, thank you so much for agreeing to do this on International Women's Day. I know that you are very much in demand today, and particularly because of this victory, that the case that you have won, which is the criminal defamation case against Priya Ramani, and you were her counsel. And I'm sure that those who have joined us today know this already, but I will say that the case was filed by MJ Akbar, formerly the editor of The Sunday, The Telegraph, and The Asian Age. And it was filed because of some tweets that Priya Ramani had made in an article that she had written during the Me Too disclosures. Now, as you all know, the verdict acquitted Priya Ramani. And because she is a woman journalist, and it is only fitting that CREA and MCRC, which is a media institute, should be hosting this conversation with Rebecca John, and we should be celebrating this victory. So, Rebecca, the thing is that while we understand law in very broad strokes, it's very difficult for us, and we are mostly unaware or uninformed about the intricacies of the law or how it really plays out. So most of my questions to you today will be in the form of seeking clarity on some of the salient aspects of this particular case. So I was wondering whether you could begin by explaining to us what is criminal defamation and how did the complainant use it in this particular case?
Thank you, Shohini, and thank you for having me on this show. To answer your question, criminal defamation finds a place in the Indian Penal Code. Section 499 of the Indian Penal Code defines defamation as, and I quote, whoever by words or either spoken or intended to be read makes or publishes any imputation concerning any person intending to harm the reputation of that person commits defamation. So this is in a sense the definition, the basic definition of criminal defamation. You have to make an imputation which is either spoken or written. You must publish it, and that imputation must have the potential to harm the reputation of a person.
But in general, could you also tell those of us, those who are attending, how this has normally been used and why so many of us feel uncomfortable with the idea of criminal defamation?
Issues such as reputation are very difficult to prove in a court of law. And what is reputation at the end of it? Most of us have opposed the use of criminal defamation because we feel the law on libel or civil defamation is sufficient for purposes of putting across one's feelings if one has been particularly aggrieved by someone's comments. But to take a person to court over criminal defamation, which has a sentence up to 2 years imprisonment, is a little harsh. It is also contrary to Article 19 of the Constitution of India, which guarantees freedom of speech and expression. So what could be free speech could be defamatory to you. And that is the reason why there was this constitutional challenge in the Supreme Court a couple of years ago. But the Supreme Court held that criminal defamation must stay in the statute books, and it is not unconstitutional. I hope we can revisit that challenge sometime in the future. And because it is necessary that we give Article 19 full play and not limit free speech in any way, unless, of course, it is in contravention with any of the other more serious provisions of the Indian Penal Code.
Right. So in this particular case, the complainant said that the tweets by Priya Ramani and the article that she wrote during the Me Too disclosures was actually affecting his reputation.
Right.
Now, there is a twisted irony over here, the twisted irony being that the victim of sexual misconduct here is the person who has to defend herself. And in such a situation where the burden of proof is on the defendant, which is Priya Ramani in this case, what kind of a legal strategy did you develop?
Okay, before I answer that question, Shohini, let me tell you what she was being prosecuted for. At the height of the Me Too movement in India, that is in October 2018, Priya Ramani published 3 tweets. One was on the 8th of October, the other was on the 10th of October, and the third was on the 14th of October. The first tweet, where she called out her male boss, she linked it to an article she had written a year ago in the Vogue magazine at the height of the Harvey Weinstein disclosures in America. And it was an article written to male bosses in general. And it is her case that she began that article by disclosing about her own first job interview at the Asian Age. Of course, she had not named the complainant in that article. So she linked the article to the tweet of 8th of October and called out her editor as the man who had sexually harassed her. Based on this, the editor, the complainant, filed the criminal defamation case against Priya Ramani. Now, I have read out the basic definition of criminal defamation 499, but what I haven't read is the fact that defamation also has a set of 10 exceptions. And if you were to plead any one of those exceptions, then of course, the structure of the case shifts. Now, while it was the complainant's case that the 3 tweets in the article defamed him, Priya Ramani claimed the first, third, and 9th exception, which in effect really says that if you speak the truth, which is in public interest and for public good, or revolves around a public question, then such an imputation is not defamation. So when I met Priya, and when she told me what had happened, and it was very clear that she was speaking the truth, I decided that this was a case which needed to be fought legally on legal terms within the 4 corners of Section 499 by invoking the exceptions. So from the very beginning, she invoked Exception 1, 9, and 3. She told the court on the first date of hearing, when the charge was read out to her and she pleaded not guilty to the case, she said that I have a defense to make, and that defense is truth made in public interest and for public good. Truth was her own experience in the hotel room in 1993 concerning the complainant and her. Public interest, because clearly public interest and public good, when you talk of sexual harassment at the workplace, it is a matter of public importance. And no one can claim that such a disclosure was not in public interest. So we combined these and we pleaded statutory defenses, which are available to an individual fighting a criminal defamation case. And not just pleaded them, we then proceeded to prove them. So when you said, when you asked me this question, how did you prove? So in law, when you plead an exception, the onus shifts on you. Otherwise, the onus is on the prosecuting side or the complaining side to prove his or her case. But the minute you prove an exception, the onus shifts to the person pleading the exception. In this case, the onus shifts to Priya Ramani. However, the law and judge-made law, the law of the Supreme Court says that even if you were to claim an exception, and even though the onus shifts on you, you only have to meet the standards of preponderance of probability and not proof beyond reasonable doubt. And therefore, Priya Ramani not only exercised her right of cross-examining the complainant and his supporting witnesses, she also then proceeded to become a witness in her own case. She was defense witness number 1, along with 2 other women who either corroborated her story or who was put up to buttress the claim of the complainant that he was a man of impeccable reputation.
Rebecca, I just want you to elaborate a little bit on exactly what you have said, because the incident in question,
Yes.
where she claimed that it happened in Oberoi Hotel in 1993, it happened long back. How does one then, develop a trail of evidence to support that?
So it's possible. I mean, in this case, we did have corroborative evidence, but when I say that she pleaded truth, she just didn't plead truth and leave it at that. The minute she stepped into the witness box, took an oath and testified before the court, the stature of the evidence is automatically elevated. She's then subjected to cross-examination by the other side. And let me tell you, nothing turned on that cross-examination because the incident in question remained intact and she was able to withstand that cross-examination. And at the end, the court gave a finding that he believed her. And therefore, truth as a defense was upheld. In this particular case, we were lucky because Priya did also have corroborative evidence in the form of another witness, defense witness number 2, who had also taken the stand. This witness was with Priya till a few minutes before she left her at the hotel. And thereafter, after the incident, when Priya goes back home, she calls her up and explains what, discloses what had happened. Now, that alone may not have been sufficient, but interestingly, these 2 women live in different cities. But when Priya made the disclosure about this incident on the Me Too platform, defense witness number 2, Nilofer Venkataraman, WhatsApped her that very day and told her that she was wondering whether she would speak out or not. And she clearly remembers what happened that night in December 1993. So we had corroborative evidence of a very high order. However, even if you don't have corroborative evidence, and as you are well aware, sometimes these incidents take place in closed rooms and you are not able to produce any kind of corroborative evidence. But I think what distinguished this case from other cases is the risk we took and the fact that Priya had the courage to withstand judicial scrutiny. She became a witness, she testified, she gave a detailed statement about the manner in which she was sexually harassed, and then she subjected herself to cross-examination. So it was no better or worse than the evidence of the complainant. And after weighing both sides, the court came to the conclusion that our side was weightier than their side.
So just to clarify for everybody that Nilofer Venkataraman indeed was the friend who in 1993 she spoke with.
Yes.
And she had, after so many years, written her a message, a WhatsApp message. And was that WhatsApp message sent before or after the case had been filed against her?
At least 10 days before the case had been filed.
So
that is the very day of the tweet.
Right, right.
And the original message was produced in court. The judge verified the message from the phone of Priya Ramani, as well as Nilofer Venkataraman. So the original messages were produced in court. And the spontaneity of the message, and Nilofer herself came as a witness. She also explained the relationship she had with Priya Ramani, the fact that she was with Priya Ramani on the day of the interview. In fact, till minutes before the interview, then post-interview, Priya had called her up that night and disclosed the incident to her. All of this, Nilofer also came to court and testified. Of course, the additional corroborative evidence in the form of the message was of critical importance to the case.
Yeah, I think because had it been done after the case had been filed, one could have said it was a setup, but this seemed kind of
there was spontaneity in this.
It was the spontaneity itself, I think, was very, very strong, in favor of you. Now, fighting a legal battle can be physically, emotionally, financially draining. And it must have been extremely difficult for Priya Ramani also, because she had no option but to be part of this case. This was a case that was not initiated by her in the first place. Could you tell us a little bit about the difficulties that she had to face during the course of the trial?
So she's not a resident of Delhi. She lives in Bangalore. And there were about over 60 hearings in this case, and she attended almost all of them. She has a young child, and naturally she had to leave her child and come to Delhi, sometimes for extended periods of time, to attend to proceedings. And it was, of course, financially draining for her. But I was particularly impressed by the solidarity that I saw both in and out of court. Inside court, there were large number of colleagues, those who knew her, didn't know her, both men and women, who came out in large numbers before every hearing to support her. That was incredibly refreshing to see. Aside from that, and Priya herself talks of it, every time she came to Delhi, she stayed in the homes of two of her, either one or two, or the other homes of two of her friends, Namita Bandare and Harinder Baveja, who stood by her like rocks throughout this trial. They were incredible. So they just opened their homes for her. She stayed with them. They accompanied her every time the court hearing was there. They would schedule their lives around the case. So it was as much their case as it was hers. And that kind of solidarity and that kind of sisterhood is something which is quite remarkable and one of the greatest takeaways of this case. So I think while Priya did go through a lot of stress, having to come to Delhi, the whole pressure of the case. She, as a journalist, she knows how to write, but the fact that she had to testify, she had no idea how to do with that space. There she became the center of attention. She was the subject of pretty hostile cross-examination. Despite all that, I think the fact that so many women supported her was something which helped her keep sane. And even for us as a legal team, seeing that support, it kind of motivated us as well, because it's not often that you see this kind of solidarity in any case.
Becky, before, I will come back to this idea of the difficulties of taking the legal route. But before that, I would like you to help us understand the judgment itself.
Yes.
We all realize that it is of profound importance for sexual harassment cases. And I was wondering, what are the salient sections in the judgment that are likely to impact on sexual harassment cases in the future?
Now, before I answer that question, Shohini, you must understand that this judgment was passed by an additional chief metropolitan magistrate. It is not a constitutional court, and only judgments of constitutional courts can act as precedents. So this is not a precedent, legal precedent in that sense. However, and the second thing which we must understand is that the judgment was passed in the facts and circumstances of this particular case. And so sometimes I've seen in the last 3 weeks, a very simplistic narrative has gone out, which says that, in any case, at any time, if women were to make disclosures, it will mean that there are no consequences. I'm not entirely sure whether you can read that judgment in that way, because if you look at it contextually, it was given in the facts of this particular case, where one woman pleaded truth as her defense, took the stand, proved her defense. And the court came to the conclusion that the exception stood proved, and therefore criminal defamation was not, the offense of criminal defamation could not be sustained, and therefore went ahead and acquitted her. But notwithstanding that, I think the importance of this judgment is that perhaps people who employ defamation as a tool to silence people, men and women, selectively, you do understand that in this case, Priya was selectively targeted, although more than 20 other women had spoken out against this editor. That may now be a questionable tactic in court, given the robustness with which Priya Ramani fought this case, and given the fact that the court gave full play to the exception and acquitted her. So I would say in the land of criminal defamation, this is a very, very important case. The comments made on sexual harassment are no less important, but they were made in the context of Priya's own evidence, where Priya said that back in 1993, there were no mechanisms which we could access. In fact, women journalists were not encouraged to speak at all. And there were multiple battles being fought at that time, battles at home. Can we work? Should you get into an arranged marriage, etc. So women were by and large told not to speak up. And yet they confided in their colleagues, and there was this sisterhood created. If you read the incredibly powerful evidence of Ghazala Wahab, who came as defense witness number 3, Ghazala says that she made the disclosures in 2018, not because she necessarily wanted to prosecute anyone, but she felt that it was the right thing to do, that women like her had suffered extreme sexual harassment, even assault, but had never been given the opportunity to disclose the events to anyone. They felt the Me Too platform gave them a safe platform to make those disclosures, particularly because younger women were making those disclosures, and they felt it was their duty as senior journalists to make these disclosures. But they were not looking to prosecute. So I think the judgment, when the judge talks of sexual harassment and the fact that women can take time to make these disclosures, was made in the context of the evidence of Priya Ramani and Ghazala Wahab. Therefore, we must view it in that context. However, very, very important observations were made by the court by saying that sexual harassment is all pervasive. We should have no tolerance to sexual harassment. And by saying that he believed Priya and he believed Ghazala, and therefore he could not uphold the contention of the complainant that he was a man of impeccable reputation. I think it's a great takeaway from that judgment.
Thanks, Rebecca. So if, for instance, there is an appeal against this judgment and it goes to the Delhi High Court, then whatever the Delhi High Court says would then become a legal precedent?
Yes, it would. Yes, it would, because it's a constitutional court.
Okay. Now, before I come to the last question and then open it up to everybody, I have another question for you, which is of great significance, is that very often we think of the legal recourse as, to sort everything out. There has been a gradual criminalization of all kinds of laws. We look to criminal law as a kind of, settle every problem kind of solution. And I also know this, that large numbers of women come to you for your counsel in cases of sexual harassment. What is usually your advice to them? Do you advise them to take legal recourse?
Shohini, I leave it entirely to the person coming to me. I, of course, have a duty to tell my client that the legal route is not always the most pleasurable route to take, and that it can be quite brutal. And I lay those facts before my client. But if my client has the capacity and wants to take that route, I don't necessarily discourage that person, of course, after weighing the nature of evidence they have in their possession. But many women don't want to take the legal route. And I respect that completely. I think women should be given the right to decide for themselves which particular route they want to follow. Some women prefer in-house mechanisms. Other women just want to talk to somebody, and so they come, they tell me and say, okay, we'll mull it over, but we don't know what we are going to do. There are still other women who feel, no, this person should be held accountable, and therefore want to access the legal route. I think that agency should be left to the individual woman. There is a lot of pressure put on women to file criminal cases. And if women want to not file criminal cases, that is their right. And people putting that pressure on women, please file cases, have no idea what women go through in courts. The kind of system we have, the endless trials that never finish, very brutal cross-examination that takes place on the stand. So women have to assess all of this before they go to court. And if women don't want to access the legal system, I think it is entirely their right. And neither courts must put that pressure on them, nor indeed the general public, because it's not the general public which is going to court and going to take the consequences of that decision. It is the woman, and the woman must be comfortable in what she does.
And that is definitely even a general phenomenon, that the process can itself become the punishment.
The punishment, yes.
And therefore, I personally think that, that point that you're making is of great significance and importance, that there can be many ways to find a resolution, and there can be as many ways as there are women, and therefore it should be left to them, and no pressure should be put on women to say that this is the right feminist way and this is the direction in which you have to move. Now, before I ask everybody to participate in this conversation, I just wanted to ask you, Rebecca, that we are all agreed, most of us are agreed that the legal recourse is not the only one, that all organizations, including institutions of learning, like the one in which I belong, we must have all internal mechanisms of redress, right? But very often we find that where we get stuck is the idea of evidence, because when a sexual misconduct happens, as has also been mentioned in the judgment, that it doesn't happen in public. It's, one person's word against the other. Sometimes there are no witnesses at all. And if there are witnesses or people who were around, may not want to rally around the person who has been subject to sexual harassment. Is there any advice that you have for women who may find themselves in this kind of a situation as to what kind of corroborative material can they gather by which it can take the form of some kind of evidence?
You're absolutely right. Very often, even in criminal cases, you're talking about internal complaints mechanisms within an organization, but even in criminal cases, other than the statement of the complaining witness, we really have nothing more. But actually, the law on this is quite evolved in India, because the Supreme Court says that when if a court at the end of a trial comes to the conclusion that the woman was speaking the truth, then there's no need for any corroborative evidence, so long as she passes the test, in the words of the Supreme Court, of a witness of sterling quality. Even in rape cases, the Supreme Court does not insist on medical evidence, because, as you know, that's a very complicated area. And sometimes medical evidence is just not available for various reasons. Therefore, I would say that if the woman's testimony is strong, and there is no corroborative evidence, that should suffice in an internal mechanism, because after all, you are not looking at proof beyond reasonable doubt. The standards of proof in an internal setup is far, far lower than in a criminal court. However, if a woman has additional material, as I said, it's just a question of marshalling that material. When Priya came to me, I did ask her whether she had, and she didn't even know the significance of what Nilofer had written to her, till I asked her, did you confide in this to anybody? And she said, yes, I confided in Nilofer. I said, and is there any, did you exchange any letters? Because in 93, that was all that was available. So she said, not in 93, but she sent me a message as soon as I put this up on Twitter. And she said that quite innocently without realizing where this was going. And I said, show me the message. And I looked at the message and I said, you're through. And it's really sometimes women don't know that these are very, very important pieces of corroborative material. Incessant phone calls made at different parts, at different times of the night, maybe. You can ask for call data records, messages, or anything else which is of significance. Therefore, if you don't have any of these of this material, you have to rely on your own personal testimony, and the committee looking at your testimony must come to the conclusion that you are speaking the truth. Now, that's a process that the committee has to follow, but it is not so difficult, because if you have a person in front of you and you are recording evidence of that person, I think by and large most people will have a sense as to whether she's speaking the truth or not. If you have corroborative evidence, then, as I said, evidence in the nature of messages, in the nature of photographs, in the nature of notes, in the nature of letters, in the nature of something he may have said to somebody else, calls made at odd times of the day and the night, etc., etc. All of this can act as corroboration to the basic complaint of sexual harassment made by the woman.
Thank you, Rebecca, for answering my round of questions. And I'm going to now ask Shalini if there are questions that have come into the Q&A box.
Yes, thanks a lot, Shohini and Rebecca. It is really an informative session for all of us. And I think we are getting many important and useful answers also to our questions. But still, I can see many people have asked questions. So one by one, I will start. And maybe I will start with Madhvi Menon has asked one question. She is from Ashoka University. And her question is, what legal chances do you expect to happen as a consequence of your victory in the Ramani case? Might it change the ways in which the court looks at the issue of sexual harassment? If so, then what might those ways be?
Okay. As far as we are concerned, as far as Priya is concerned, she's acquitted. So there are no further consequences to face. But the complainant has the right to file an appeal. And if he does so, it will come up in the Delhi High Court, in which we have the right to contest the appeal. Who knows? It might end up in an even better judgment. We don't know. Now, what would be the impact of a judgment of this nature on other cases? That's a complicated question, because every day we take 2 steps forward and 5 steps backwards. And we are seeing that in what courts are doing as far as these cases are concerned. We've also watched with some degree of horror some of the comments made in the last week by senior judges. So I don't think we're anywhere close to having a settled law as far as sexual harassment at the workplace is concerned. Vishaka came in 1997. It was implemented as a statute only in 2013. Most offices were not compliant till a few years ago. I don't know whether they are fully compliant now. There is this large sector of unorganized women, domestic workers, who cannot access the law, where the local complaints committee is toothless and is not really giving them any form of giving them any redressal. So on a larger platform, my answer is not very positive. I think we still have a very, very long way to go before we can have settled jurisprudence, consistent settled jurisprudence on sexual harassment at the workplace. The law is there, right?
Yeah.
And the law can only evolve and better itself. But we can't be in a situation where one day you have a great judgment and the next day superior courts are talking in this way. We also had a set of judgments passed by the Nagpur bench of the Bombay High Court in POXO matters, which were quite which was quite troubling. So there has to be consistency. And I don't think I can, just because we won this particular case, I can be in a position to say that we are in a perfect place. I don't think so. I think a lot more needs to be done both inside the judiciary and outside. A lot more sensitivity has to come amongst our judges while they view these offenses. There has to be a much better understanding of these offenses. There's need to feminize our trials. There is need to change the language we speak in court, both from the bar as well as from the bench. None of that is happening anytime soon.
Okay, thanks. So we have another question from Shampa Sen Gupta. She is director of Shruti Disability Rights Center. And actually, she has shared her personal story, and she has said that she wrote her Me Too story about like how she was harassed by a very famous, like iconic figure from disability Indian disability movement, and who was a blind a person. And her story published in 2018. She didn't mention his name, but because he was so famous, everybody understood about him. After that story, many other women also with and without disability wrote to Shampa separately, and they also shared that they faced similar harassment from the same person, but they were not ready to come out in the open. This person died in 2020, and one of the disability activists mentioned that during obituary postings that there is alleged complaint against him, thus giving out his name. And in 2020, after 2 years of writing her account, his fans started giving threats that they will bring defamation case along with his family. Now Shampa is asking that can someone else file defamation case on behalf of person accused? What legal measures a woman can take when such threats as mentioned above are faced?
Yes, that's again a legal question, so I'll
Yeah.
answer it legally. The law permits, even after the death of a person, the law permits a criminal defamation case to be filed, but the person filing it has to be a person aggrieved of the defamatory statement or the imputation. And person aggrieved has largely been interpreted as persons who are either close family members or very, very close associates, who can claim that kind of nexus between the person who's no longer alive and the imputation. So it is not outside the purview of the law that a case cannot be filed. It can be filed because the law permits that even after the death of a person, the complaint can be filed by a person aggrieved. I don't exactly understand the chronological sequence of what happened when, but I'm assuming that the imputation was made either soon before his death or after his death. If that is the case, then if somebody wants to file a criminal defamation case, it can be filed. Whether it is sustainable or not sustainable, that's a separate issue. If such a case is filed, as I said, the one thing that the Priya Ramani case has opened up is that if you are knocked up, if a case like this is filed, then you should be willing to give it as hard as you get. And we were very aggressive in our defense because we saw no reason to be polite about something as deeply offensive as this. And this is my only advice. Should a case be filed in this way, there are legal remedies available in the law. Exercise those remedies. You will need to contest this in a robust fashion. And if you do, there's no reason why you should lose. Of course, it means that you go to court, you're dragged to court, and a couple of years of your life is spent fighting this case. And that's a heavy price to pay.
Yeah. Thank you. We have another question from Professor Bulbuldhar, and she's from Political Science Department, Jamia Millia Islamia. And she's asking, does this, in a sense, redefine defamation in the context of the court's premise that women cannot be punished for raising their voice against sexual abuse through the pretext of criminal complaint of defamation? Also, the fact that the right of reputation cannot be protected at the cost of the right to life and dignity of women as guaranteed in the Indian Constitution. So, like, she's also asking, I think, is also like creating a environment which will maybe prohibit many women to come forward and talk about their cases?
See, again, I've answered this question because Shohini asked me this question. It doesn't give you blanket protection, and if you were to oversimplify the judgment and say, you can say what you want to 50 years from now, and it will protect you from a slap suit or a defamation complaint, then that's wrong. What this judgment really did was to look at Priya's case. And because Priya had given an explanation as to why she did not make the disclosures in 93 or in the 90s or in the early 2000s, and she gave an explanation. So in that context, the judge said that it is possible that these things happen. And that explanation given by the individual is something that I consider to be valid, and I therefore take it on board. Will it have universal application? I'm afraid it will depend on the facts and circumstances of every case. A judgment in a criminal case is based on the facts of that case. So I wouldn't want to use this platform to somehow tell everybody that you are protected from prosecution. That is not true. You could still be prosecuted. The only way that was shown in this case was that if you are prosecuted, this is the way to fight it.
Yeah. We have Faz Ullah from Tata Institute of Social Sciences, and this question is talking about internal complaint committee. So question is, ICCs are often more interested in protecting the company,
Yes.
if not the offender, than the aggrieved person. What has been the experience of your clients of functioning efficacy of internal mechanisms?
Very good question, and I think it's time to revise and perhaps amend the law, because we've seen the ICC functioning now for about 7 years. And one of the regular complaints I get is that it is almost impossible for a group of individuals who are part of an organization to rule against a person who is holding a position superior to them. If it's an inferior designation, it's still possible. But anyone who's holding a position superior to them, then it becomes very, very difficult. Which is why I have been saying for the longest time, not that that's the perfect solution, but perhaps we should look at increasing the number of external members to the ICC, so that the top-heavy internal members, a balance is created. Presently, there's only one external member, but if you have more than one external member, then you will be able to restore balance to the committee. And if you have to rule against a powerful person in the organization, at least that committee will have the teeth to do so. So I think the composition of ICCs is something that we should look to challenge in the future. And I hope the law evolves considering these ground realities, because it's very, very difficult. And I've seen this in case after case to rule against men who hold senior positions in the organization.
Thanks, Rebecca. Actually, there are many confusion and questions related to ICC, not in the question box here also, but many times people have been asking about this. And mostly, but I think many people have been complaining that ICC members don't try to also build their capacity around this law and issues and what is the purpose of this law. And they maybe totally depend on the third party person. So they don't take a step within their company also, within their office also. But when case comes, they go to the third party person and then they start the process. But before that, for the prevention, many times companies are not doing enough. So this was the one of the experience actually many people have been sharing.
And you need to follow it in letter and spirit. And I noticed that the spirit is not there because now you have to be compliant with the act. So they have set up committees, but there is no endeavor to try and give teeth to those committees, to train them, to understand the various aspects of sexual harassment. So that is completely lacking. Also, the Sexual Harassment Prohibition and Prevention of the Workplace Act it's not, it gives you a broad framework, but nothing stops an organization to deviate from that framework if that works for that organization. So
Yeah.
even now, while it says there must be so many women in the committee, nothing stops the organization from having 2 or 3 external members in
Yeah.
a particular case, if the person accused of the crime is somebody who's very, very serious. So
Hmm.
I think organizations also must show some flexibility. The act only is in the form of guidelines. It guides you as to how something has to be done, but nothing prohibits an organization from doing something which works well for a particular case. And you can review the composition of the ICC on a case-to-case basis. You don't have to have an ICC which is permanent for all times to come. In any way, they have a 3-year tenure. But you can review it. If the allegation is against a very senior person, you can review the composition of the ICC. So these are things I think it's being done mechanically. There needs to be a lot more effort put into the working of the ICCs, and unless that is done, this act will become like any other act, which is followed in letter, which is there but not followed in letter and spirit.
Yeah, thanks. So many people are actually also congratulating you, Rebecca. So one of the messages I just wanted to read from Anuradha, and she has written, "Congratulations once again and on the wonderful way you have managed to achieve justice for Priya Ramani, and hope this offers for several others also, as it's one step forward and a step back. What needs to be done? What needs to happen in the form of interventions in the with the judiciary to ensure this is consistency in upholding women's rights?"
Okay, now
So there is consistency. Yeah. In the
I don't know where to start. But as I said earlier, um, and somebody asked me this question, whether what I look forward to this year, on the eve of Women's Day. And I said, I look forward to a year where the language inside courts change. I think it's a very important message when language changes. It doesn't matter whether you win a particular case or you lose a particular case. And there have been many cases where judges have genuinely felt that the evidence in the case does not justify a conviction. As a criminal lawyer, I will never, ever uphold a system where you are convicting people on very, very shoddy evidence. So if a judge has doubt, he must acquit. It doesn't matter who the accused is or who the victim is, but if the prosecution has not been able to prove its case beyond reasonable doubt, then an acquittal must and should follow. But while doing so, you must be respectful of victims of sexual assault and sexual crimes. And you must not use language which is so problematic that it has a rippling effect on other cases. So it's really, I mean, you may be saying something in the facts of that particular case, but your language is being picked up and is being quoted, and it sends out a message to the lower judiciary, to other courts, that this is okay to talk in this manner. So what I look forward to this year is not any change in the law. Our law is fine. It is robust. It has enough and more changes, and it really requires no further changes. What I look forward to is a change in the language used inside courts, both by the bench and the bar. If we are able to achieve that, and if we bring back respect to proceedings and respect to what a particular person has gone through, irrespective of the final result, I think there will be a lot of change.
So we have another question from Arvind Ansari. And question is, do you think Priya Ramani got favorable judgment because she had Rebecca John as her counsel, who could also relate to her as women, as you rightly said, feminize our trial?
I'm sure there are other women who could have done an equally good job, if not a better job. But what this also throws up is the fact that this was a trial that was happening in Delhi, right? It received a lot of media attention. an entire legal team worked on it. But what about those cases that take place in the far corners of our country? What about those cases of assault, of grievous assault that take place in the interiors of our country? Nobody talks about it. If you look back at the history of these laws, look at what Mathura faced. Look at what Bhavari Devi faced. And these are some of the more famous examples. But this is happening on a daily basis, where the bodies of women are used by men to exercise power and show their power. And very rarely do we get to hear about it in the national media. So I really think the focus should move away from the Priya Ramani case to these forgotten tales and these forgotten cases in the far corners of our country. And people should pick these cases up. If they have not yet got over, then there is need to make interventions and ensure that justice is given to the victims. But even otherwise, I think we are already facing the charge that both the Me Too movement and the Priya Ramani case was, came out of privilege. They were upper class women. The Me Too movement itself was an urban movement. But what about regular harassment that, say, a construction worker faces inside a factory, inside homes? Do we even talk about it? So I think the conversation should now move away from the Ramani case to these forgotten cases across our country.
Thanks once again. And like Rajni is writing, congratulations, Rebecca, for your victory and for your very informative talk today. She has a very specific question. She says that we have seen that with every judgment, the definition of sexual harassment seems to either expand or contract. Some of these definitions may even be shaped by complicated belief systems, prejudice, or may even just be confusion. How are we to negotiate these issues in the public domain?
I wish I had an answer to that. I think our contest, we can only change this through our contestations. What is acceptable, what is not acceptable. And every time we critique a judgment and we put it out there that it is not acceptable to talk about women and their experiences in this manner, perhaps we are changing the discourse for future judgments. But it is the way we challenge and contest that is important. That is what I have learned. And I hope the space changes eventually with more and more women coming into the workspace, with more and more women accessing law, with more and more women saying that they will not tolerate any kind of harassment. I'm sure that space will change.
So another question is from the larger perspective that Simona Shawnee is asking, could you briefly assess the impact of Me Too on the Indian judicial scene?
Okay, so we had different kinds of judgments coming out on this. In civil defamation cases, in fact, there was a judicial backlash where the judiciary was saying, what is this Me Too, and how can you just name people, and what recourse does the person who has been named have because you plastered his name on social media. And so there was a backlash. I don't think there were criminal defamation cases or criminal cases filed against women who had named their male bosses other than the Ramani case. I could be wrong, and if I'm wrong, I'll stand corrected. But there were many cases where men filed civil defamation cases, and the response of courts was not very encouraging. So it is a complicated landscape. As I said, it would require far greater work, and it would require courts to understand the meaning of this offense and why women speak out late. There was some understanding in this judgment. But as I said, that understanding also came because of the nature of evidence led. I will not be able to say as a matter of certainty that courts across the country have viewed this as a movement which requires judicial certification. On the contrary, there has been quite a bit of backlash in a lot of the civil defamation cases filed.
Thank you. We have another question from Anuradha. Again, she has not written, I think, her organization name. So I will just check. She's wondering if our local governance system provides any platform for any woman who wants to raise an issue of ex informal, like for cases, example, informal workplaces. So we have been like going through this struggle between informal and formal, organized and unorganized, and many people have these questions. Actually, here maybe Anuradha is asking, but this question also we regularly face. So she is asking, as many workplaces can be also beyond companies, then how do you think
Yeah,
about
so you
providing?
access what is known as the local complaints committee, and it really depends. There is no uniformity in the way they behave, but I am increasingly seeing in some local committees in Delhi that they are, in fact, being quite open to taking complaints from the unorganized sector, and particularly if it's a one-to-one thing, they are actually entertaining those complaints. I think there is also need to put these LCCs under training, so that we can tell them how far they can go under the law. As I said, the law doesn't prohibit them from doing any of these things, but it's their own inhibition which prohibits them from taking on these cases. So the LCCs need to be far, far more proactive, because they are dealing with a large section of women who are at the workplace. The organized sector will deal with them in an organized way. It's the unorganized sector which needs to be looked at very carefully, and that's where the challenge lies.
Okay, so this question was from Anuradha Kriya, she has added. Now we have last question from Dr. Shikha Kapoor, and she's asking, first women facing workplace harassment feel great pressure to go and file file cases. Thereafter, the case takes long. How
Yes.
should our judiciary respond once these cases come up in terms of speedy trials and hearings?
What can I say when murder cases take 15 years to complete? In the structure and the hierarchy of criminal cases, unfortunately, speed is always a casualty in India. And when murder cases, rape cases, cases which have caused intense harm to people are taking 15 years before they're completed. We just read a judgment yesterday where 122 people were acquitted in Gujarat for a crime they did not commit after more than 20 years. So the expectation that these trials will be finished in less than 2 years is an unfair expectation, because that is just not going to happen in our system.
Thanks a lot, Rebecca. This was my last question, so I will ask like over to Shohini, please.
Rebecca, thank you so much for spending so much time with us, so being so patient in answering all the questions. And I want to thank everybody who has attended today's session. It's a Sunday morning. I'm sure, you've had to make time for this, but I want to thank each and every one of you for being here, for participating, and for asking your excellent questions, which has thrown so much light on so many different kinds of issues. Thank you so much, Rebecca. On behalf of Radio Jamia, AJKMCRC, and CREA, I thank you once again for spending time with us for International Women's Day. And I hope and promise, actually, that we will continue to have conversations about what we can do about sexual harassment in workplaces. How can we build more robust redressal systems that are also fair to everybody?
Absolutely. Thank you so much, Shohini.
Thank you.
And have a wonderful year, wonderful Women's Day.
Thank you so much.
Thank you.